Welcome to one of the most explosive property dispute cases we've seen this year. Today, we have a plaintiff accused of calling in the zoning police on her own house, allegedly as a pretext to kick out lawful tenants who'd already invested over $100,000 into the property. The defense says this was an illegal lockout. The plaintiff says it was justified. But here's the twist. This case isn't just about property. It's about broken contracts, personal lives torn apart, and the possibility of triple damages under Michigan's lockout law. Stick around because by the end of this, you'll be questioning who's really playing fair in this courtroom.
It took me a while. When we were at one of the first hearings, I got Miss Hines' pleadings. I saw that email and she was indignant that the defendants were in there and they were removing property, and she contacted the undersheriff, and I was aware tangentially of the zoning action. There were several actions going on in the summer of 2022. There was a personal protection order between Mr. O'Donnell and Mr. Verpalat in August and July. That was going on. Then there was the zoning case, and that was in the name of Rosemary Blair and the other owners of the property, not in the names of the tenants. And then that was settled. She owned the property. She accepted the settlement. Officer Kuhlman indicated that the property had been made habitable, and I have the PPO file, I have the zoning file, and this file. So as we got into the hearing and I started to hear Mr. O'Donnell's position, I was offended. Maybe outraged is too strong of a word. My opinion at that point was the plaintiff used the zoning system to force the defendants out of the house. And I have some serious concerns about violation of the lockout law. I felt that they got used. She self-reported a zoning violation. Allegedly, there had been some damage to the deck, but the photographs showed just minor damage to the deck from apparently a tree that had fallen earlier. And then they got under the house and realized that some of the stuff was supported by bottle jacks and it may have been dangerous. So they condemned the house immediately without notice to Mr. O'Donnell and Miss Bowers. And I believe the plaintiff used that as a pretext to terminate the lease with option to purchase. Miss Bowers and Mr. O'Donnell were the lawful occupants of the property on the day that zoning enforcement action took place. The police came out there I won't say it. Anyway, they came out there. Miss Bowers was asleep. The house was neat and clean. All the beds were made. They were using it for the purpose they had intended. And they came stomping in there, got her out of bed, kicked her out of the house, told her she couldn't stay there, and they were evicted. And I felt at that time, I haven't made a ruling yet, that it violates the lockout law. Then they changed the locks and did some other stuff. And some earlier attorney sent an extremely threatening letter saying, nah, rah, rah, rah.
Your Honor, those letters, if you're looking for them, are Exhibit 9 of our brief. in opposition to the motion relief.
They're in the original pleadings as well, but the lockout law, which is found at 600.2918. Any person is rejected and put out of any lands in a forcible and lawful manner and is afterwards being held or kept out by force is entitled to 3 times the amount of his or her actual damages, or $200,000 or $200, excuse me, whichever is greater. Paragraph 2, any tenant in possession of premises whose possessory interest has been unlawfully interfered by the owner is entitled to recover the amount of their actual damages, $200, whichever is greater. And I think there's a position in there also for attorney fees. By changing or altering the locks, this is 2F, by causing by action or omission the termination or interruption of services provided. They called the zoning people to ask them to condemn their own house. And then they used the section of the lease option to purchase that says under destruction or condemnation of the premises, if the premises are damaged or destroyed by fire or other casualty to the extent that the enjoyment of the dwelling is substantially impaired, landlord in its sole discretion may elect to repair the premises or terminate the lease upon 30 days written notice to the tenant. Well, that wasn't even done. If the premises are condemned and cannot be repaired, this lease will terminate on 20 days written notice by either party. So on the day the zoning police show up, Mr. Bowers, Miss Bowers and Mr. O'Donnell have a lease with option to purchase effective November 15th of 2021 with 0 monthly payment. However, the testimony at the earlier hearing was they had given Miss Blair $85,000 plus an additional $15,000 plus some other money. Their testimony was they were paying $200 a month, although the lease did not require that. What's really going on is this is a purchase price for $450,000, and this house is probably worth $800,000 to $900,000. A $450,000.
Now, let's pause for a second, because this is where things get legally spicy. The judge is pointing to Michigan's lockout law, which says if you're unlawfully removed from a property, you can get 3 times your actual damages, plus attorney's fees. That could mean a massive payout for the defendants here. But think about the motive. If the property's worth nearly $900,000 and the agreed purchase price was just $450,000, wouldn't the seller have a huge financial incentive to make that deal disappear? Here's my question for you. If you were in the seller's shoes, would you honor the deal? Or would you find a loophole to get your property back? Drop your thoughts in the comments, because I think this is where the real ethical battle begins.
Sale price in this market for this house is a very low price. At any rate, they called the zoning police on themselves, condemned their house, immediately kicked the defendants out, attempted to change the locks, and this action was begun. Ms. Hines was indignant, and then I said, well, I'm not sure your client has clean hands. Well, then she was more indignant. I hadn't made any finding at that point, but that was my impression at the close of that hearing. And I'd seen the zoning case. I saw the very minor damage to the deck. And then it started out as this. So the lockout law could allow the defendant to claim 3 times their actual damages plus attorney fees. So it is a summary proceeding action. There's all this other stuff circling around, but it boils down to the defendants want to execute the contract, which is a specific performance action. The plaintiff contends in some of the pleadings that she wasn't competent or capable to enter into such a contract at that time. Specific performance is an equitable remedy, mostly rests in the circuit court. So that's a concern that you should have on behalf of your client, whether they violate the lockout law, and she's going to be liable for 3 times the amount of their actual damages plus their attorney fees. And the question is whether or not they can execute the contract. So she wants the house back, but they have a lease. They had a lease that was in effect at the time, and they did an end around the lease by using a zoning action. I'm not sure whose idea it was. The PPO action was going on at the same time. The zoning enforcement people also get a phone call saying they want their house inspected, again with 0 notice to the tenants in the house. So they were out. Miss Blair, I think, has been paying the utilities. I'm not sure if anyone's mowed it or anything, but your clients aren't here. I was hopeful they would be here. What do they want?
Yeah, they want, at the end of the day, they want to consummate the transaction, which is our counterclaim for specific performance. And they also want to be made whole for their damages. Outside of the monetary damages, we have, I think, nine claims in our counterclaim, excuse me. In addition to consummating the transaction, which I have offered to sit down and try to work out with opposing counsel, but it hasn't been fruitful. They need to be made whole for the damages. Mr. O'Donnell has 5 children. So if Miss Blair claims that she was stressed by receiving the counterclaim, imagine the stress that Mr. O'Donnell had on his life and his kids' life when they were unlawfully evicted from the property, didn't have anywhere to keep his 5 kids. His relationship with Miss Bowers fizzled out after that because she was so distraught that 2 men came into the house when she was sleeping twice without warning and searched the premises, which she didn't know anything about. So it's ruined his personal life. It's really put a strain on his relationship with his children and where they're at. So at the end of the day, that's for a different hearing on the 26th, but they want to consummate the transaction. They've already provided Ms. Blair with over $100,000. And then also to be made whole for the damages that they've incurred by finding alternative housing and the attorney fees, which are very high at this point because we've had to file countless motions that I think are improper under the court rules. They're seeking to extend the time. There should be a default entered. Now there's a motion to extend the default, which is improper under the court rules. It should be a motion to set aside a default judgment, which they don't have a.
Well, I haven't actually entered it yet.
Right.
So.
Right. So yeah, procedurally, I guess, but the motion for extension of time will get there because it's the next motion, but the grounds aren't there and the relief can't be granted by the court. So, if they want to try to have a pass at the default under 2.603, the motion to set aside the default, they have to have a meritorious defense and good cause, which they don't have. But to answer the court's question, at the end of the day, we would like to consummate the transaction. Mr. O'Donnell would like to move back into the house that he put a lot of work into and paid over $100,000 for. And then also he wants to be made whole for his actual damages after the wrongful eviction.
There's one other thing that you failed to mention. At the time, they had given notice to Mr. O'Donnell if they wanted to execute the sale within 30 days. I don't remember I wrote it down, 90 days.
90
so
days.
He had started working with a financial lender to complete the transaction. And his testimony was it was his intention to complete the purchase of the home.
He was ready, willing, and able with the 90 days from Ms. Blair when she said, I want to move forward with the purchase price to purchase the house. After that time, I believe that was August 4th. After that time, the pretextual zoning condemnation happens. They get illegally evicted from the house. And then now she files a summary proceeding to recover possession of the property, which is ironic in itself because she already had possession of the property because she illegally evicted them from it. So, and one more thing, Your Honor, too, The lease with the option to purchase, which is a land contract, that Miss Blair now claims she didn't have the mental capacity to sign because she has lymphedema, which is swelling of your lymph nodes, not a mental capacity order, doesn't affect your cognitive ability. That's the very contract that her lawyer relied on, Mr. Yonker, to terminate under the condemnation term of that contract. So when she was illegally evicting him, she used it to kick him out. And then now that she's stuck with it because the terms aren't beneficial to her, she's saying, I didn't have the capacity to execute that contract because I had lymphedema and I was in pain.
Well, where I was going was the interest rates have substantially gone up. The money that Mr. O'Donnell would have been able to borrow in August of 2022 and what he has to pay interest to borrow it today, I'm sure has greatly increased. And so I'm not sure what's going on behind the scenes, but they're certainly, their position is much worse than it was at the time. And that theoretically, that contract is still in effect. Now it's expired because of the legal action. By theory, they were supposed to complete it by, I think it was November 30th. At any rate, it has not been completed, but his testimony was once she gave him the notice, he was ready to complete it. And then this pretext zoning action took place, which resulted in them being removed from the house. My more specific question is, what do you want me to do the next 30 days? Just leave it as it is in the status quo that neither party is in it?
No, Your Honor, just in response to the motion to lift the no entry order, we obviously want you to deny that in favor of Ms. Blair. We want you to enter the default under 2.603 because under our counterclaim, we have a claim for quiet title, which is properly before the court, and the court does have jurisdiction when it's coupled with a summary proceeding, and the summary proceeding action where we are entitled to possession of the property. So it's really the opposite. We want Mr. O'Donnell and Ms. Bowers to be able to go back into the property, and then the hearing on the 26th is the evidentiary hearing about their damages.
All right.
Oh, I'm sorry, one more thing, Your Honor, too, if I may. After they were evicted from the property, all of their personal property was removed by Ms. Blair from the property. Snowmobile, snow blower, countless items in the garage, it was all taken out of there by Ms. Blair. And that's what our conversion and statutory conversion claim pertains to.
And the problem with those items is they're all over $25,000. And where are those things?
I don't know. We made a demand for the return. We don't know because we didn't take them out of there. I do know, I did talk with Michigan State Police Officer Trooper Owen, who was involved when Miss Blair was calling, how do I say this nicely, calling a lot the Michigan State Police and trying to report Mr. O'Donnell for coming back to the house when he was locked out, saying that he was breaking into the house and trespassing in the house when he had a lease that allowed him to do that. I did speak with Trooper Owen. He will be testifying at the 26th hearing, and I think the judge recommended that at the January hearing. He did tell me that the snowblower was in some salvage yard. Mr. O'Donnell doesn't know where that's at. We've demanded all the personal property back from Miss Blair. She hasn't returned any of it.
All right. So your position is you win by default. And then the question is, what do we do with the lockout law and the other issues of damages? And they should be entitled to immediate possession.
Correct, Your Honor. Under Quiet Title and the Summary Proceedings Act that we have in a counterclaim, the default establishes liability. Our client is entitled to immediate possession. The hearing on the 26th, and I do understand the reason we had the allegation in our counterclaim that some of our claims, which is really our statutory conversion claim, may exceed the $25,000 limit, for jurisdiction for this court is because of the treble damages associated with that. That's the only reason that I pled arguably one of the claims is over $25,000. Now, the proper procedure for that is MCR 4.002 that says if a claim outside the district court's jurisdiction is coupled with other claims in the court's jurisdiction, that claim is bifurcated. So typically what I do is I file a motion for bifurcation, or opposing counsel would just stipulate to it. We could remove that claim to the circuit court. But this court does have jurisdiction over the summary proceeding and also the quiet title claim.
And I don't want to, my preference would be to get this all the way to the finish line. I don't want to do part of it and then dump this all on the circuit court. Or at least get it in a procedural posture that, because it's really going to delay things then. Transcripts will need to be prepared. It's going to take a year or more to resolve it if it's removed to circuit court.
So here's where we stand. The defense wants the court to rule in their favor by default, granting them immediate possession of the property and moving forward with damages. The plaintiff side, they're fighting on multiple fronts, questioning the contract, disputing their own capacity to sign it, and raising jurisdictional challenges. Beyond the legal jargon, this is a cautionary tale about real estate deals, trust, and how fast things can turn when relationships break down. The stakes are high. Hundreds of thousands of dollars, a family's home, and a question of integrity. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.